Today, we will explore the relation between Article 142 and statutory provisions. So, it is a big topic. It is having long history from 1963 onwards. Still now, this issue is going on. So, we know that Article 142 deals with the power of the Supreme Court to do complete justice. The matters pending, cause or matters pending before it. So, it is a special power, a completely in a different footing, different quality. It is not an ordinary statutory provision. So, while exercising this power under Article 142, can Supreme Court ignore the relevant statutory provisions? Can Supreme Court bypass this statutory relevant statutory provisions or has to take it into consideration? This is the issue. So from 1963, that is 1962, reported in 1963, Premchand Garg judgment is there, an excise commissioner. So first time the limitation has been imposed against this article 142. What is that limitation? The limitation is that the order passed by the Supreme Court under Article 142 should not inconsistent with the statutory provisions. Now we will see the relevant portion. Edge. Okay. Now see the Premchand Garg case. Yes. In the interest of justice, the powers of this court are no doubt very wide and they are intended to be uh, exercised in the interest of justice, but they should not inconsistent with the fundamental rights guaranteed by Part 3, and they should not inconsistent with the statutory provisions also. You see here this observation. Cannot be inconsistent with the substantive provisions of the relevant statutory laws. So that is the observation. And the judgment has given instances where Supreme Court can exercise the powers. Instances, that means examples. See, these examples are that like what do you call implement, amending power, and additional documents. Okay, additional evidence, allowing additional evidence, remanding the case. This type of examples given. According to the judgment, this can be done. According to the judgment, this can be done. Admitting additional evidence, remanding the case, allowing the new point to be taken for the first time. So like this. Okay, the other thing is that, so the first time there is an imposition of limit on this point. Next, the next judgment is 1988 Antule case. In Antule case, you know the facts of the case. In Premchand Garg case, what happened? A rule has been challenged. What is that rule? The rule imposing the applicant who is coming before the Supreme Court to have to pay security. That means to pay the cost to the respondent. Those who are approaching under Article 32, the Supreme Court, they must pay cost to the respondent. That rule has been challenged. Supreme Court held that. So in this case, 145 rule making power of the Supreme Court, 142, these two rules and Article 32 were compared. So while arguments, a lot of discussion took place, finally Supreme Court told that power of Supreme Court under Article 140 it is very wide, but it should not inconsistent with the fundamental rights. Okay, then come to what he called Antule case. In Antule case, you see, the facts of the case is that in Antule, Supreme Court in 1984 passed a direction. What is that direction? You know that Antule was the Chief Minister of Maharashtra. Some allegations are there against him. So a case has been registered and a special court constituted under the Special Amendments Act, Criminal Law Amendments Act 1952. According to that act, a special court has to conduct a trial. But in 1984, what Supreme Court has done? Supreme Court has given a direction stating that the matter has to be heard by the High Court. That means Supreme Court transferred the case from special court to directly High Court. So after some proceedings, the case has been again come to Supreme Court in the year 1988. So then what Supreme Court held that the earlier order passed by the Supreme Court is wrong, because Supreme Court has no power to make legislation. Supreme Court has no power to give jurisdiction to a special court. It is a duty of the legislation. So here see, lack of jurisdiction, because Supreme Court has provided power to the High Court, the power of the special court. Normally, the case has to be tried by special court. Because of it is transferred to the Supreme Court, High Court, what happened? The Antule, the petitioner lost one case, one step of the revision. He could not file revision now. If he suffered any conviction, he suffered any defeat in the trial court, he has a chance to approach the High Court. But here, because suddenly it's straight away transferred to the High Court, the applicant cannot file a revision. So this is called entrustment of the power, jurisdiction to High Court. That can be done only law, not by Supreme Court. So that is wrong. That was not authorized by law. So in Antule case, the court held that upheld. The court upheld the law declared in Premchand Garg. It says that Article 142 cannot cannot be exercised in inconsistent with the relevant statutory provision, because 407 of the CRPC is there. It is giving some power to High Court, Supreme Court, regarding transfer of criminal cases. Here, however wide and plenary the language of the article, the directions given by the court should not be inconsistent with, repugnant to, or in violation of the specific provision of any statute. If the provisions of the 1952 Act read with Article 139A and 4 of the CA do not permit the transfer of the case from a special judge to the High Court, so that effect cannot be achieved indirectly. So the CRPC is not permitting, 1952 Act is not permitting, but Supreme Court has given such a direction. That is wrong. So exercising Article 142 in such a way is wrong. The next case is, this is happened in 1988. Union Carbide, some observations is there. Thereafter, in 1991, Delhi Judicial Service case is there. In this case, some sort of difference observation given by the Supreme Court in Delhi Judicial case. So here, what is the observation of the ratio held by the Supreme Court is that Supreme Court power under Article 142 is a constitutional power. So ordinary law never control, never limit the power of the Article 142. See, since the Supreme Court has power of judicial superintendence, the tribunal functioning direct protect, the subordinate and inferior do not have adequate power that this court should protect. Under the constitutional scheme, it has a special role in the administration, justice. And it has held that Article 32, 136, 141, 142 form part of the basic structure. Form part of the basic structure of the Constitution. So, the amplitude of the power of the court under these articles cannot be curtailed by law made by central or state legislature. This is the different view. So, the Premchand Garg says that, Antule case says that the exercise of the power under Article 142 should not be inconsistent with statutory provisions. A little bit difference is there in the Delhi judicial case, that these are basic structures of the power under all these articles form part of the basic structure. So ordinary laws cannot curtail the power of the Article 142. It would never almost plenary, the inherent power of this court under Article 142 coupled with the plenary and residuary powers under Article 32 criminal proceedings. So, no enactment made by central or state legislature can limit or restrict the power of this court under Article 142 of the Constitution. Though while exercising power under Article 142 of the court must take into consideration, so Here he has given some relaxation. What he says, the court must take into consideration the statutory provisions regulating the matters in dispute. But once the court has taken session of a case or cause or matter, it has power to pass any order, issue directions may be necessary to do complete justice in this matter. So this is the observation in Delhi judicial case. Next, come to another judgment. Here the facts of the case are that in Delhi judicial case, what are the facts? One chief judicial magistrate has been arrested by the police fraudulently, handcuffed him. So deliberately filed a false case. So by exercising all these powers, Supreme Court quashed those criminal proceedings. Now come to another judgment, that is Ahlawat case. Before that, SCBA case. SCBA case is very important. Supreme Court Bar Association case versus Union of India. This is very important regarding Article 142. Because okay, what is the observation here? See, SCBA case is, the facts of the case is that facts of the case are that an advocate has been convicted under contempt of the court act by the Supreme Court and also passed punishment of suspending the license of the advocate. So can it be done or not? While passing punishment, Supreme Court cannot suspend the license of an advocate because it is the duty of the Bar Council. Suspending the license of the advocate is duty of the Bar Council. By ignoring the Bar Council, a statutory mechanism, Supreme Court cannot pass. So here, see what is the observation of the Supreme Court. However, the powers conferred on the court by Article 142, being a curative nature, cannot be construed as powers which authorize the court to ignore the substantive rights of litigant while dealing with the cause pending before it. This power cannot be used to supplant substantive law applicable to the case. Here, the supplant means what? Supplant means replace. Replace or supersede. Article 142, even with the width of its amplitude, cannot be used to build new edifice. So, the plenary powers of this court under Article 142 of the Constitution are inherent of the court, are complementary to those powers which are specifically conferred a court by various statutes through, though are not limited by those statutes. So here the first time the concept of supplementary and complementary to the statutes has come into picture. So SCBA case held that the powers of Supreme Court under Article 142 are supplementary or complementary to the statute powers. These powers also exist independently of the statutes with a view to do complete justice between the parties. These powers are of very wide amplitude and are in the nature of supplementary powers. These powers exist as a separate and independent basis of jurisdiction. Apart from the statutes, it stands upon foundation, and the basis for its exercise may be put on a different and perhaps even wider footing to prevent injustice in the process of litigation and to do complete justice between the parties. The plenary jurisdiction is thus the residual source of power which this court may draw upon as necessary whenever it is just and equitable to do so, and in particular to ensure the observance of the due process of the law to do complete justice between the parties. So while administering justice according to law, it is an indispensable adjunct to all other powers and free from restraint of jurisdiction, and operate as a valuable weapon in the hands of the court to prevent clogging or obstruction of the stream of the justice. This is the observation. And also, however, the powers conferred on the court by Article 142 being curative in nature. So here, what is the court observation? This is not supplementary substantive law. It is even without width of its amplitude cannot be used to build new edifice, ignoring express statutory provisions. The same. In SCBA case also, so what is the ultimate decision? The suspension of license of an advocate is wrong because we cannot completely ignore. You see here the word. By ignoring express statutory provisions, dealing with a subject and thereby achieve something indirectly which cannot be achieved directly. So in SCBA case, Supreme Court is saying that we cannot ignore express statutory provisions while exercising Article 142. Ironing out, so the very nature of the power must lead the court to set limits for itself within which to exercise those powers. It cannot disregard a statutory provision governing a subject, except perhaps to balance the equities between the conflicting claims of the litigant parties, ironing out the creases in a cause or matter. So here, we cannot disregard a statutory provision governing a subject. So this is the observation. And the nature of the Supreme Court, it is well recognized and established. This court is always been a lawmaker and its role travels beyond merely dispute settling. Supreme Court is not only dispute settling court, lawmaker, problem solver in the nebulous areas. We have to understand that Supreme Court is problem solver in nebulous. Nebulous means vague situations, uncertain situations. So in that areas, Supreme Court has power. It cannot be altogether ignored by this court. So this is the power of the article according to 142, according to the SCBA judgment. So SCBA judgment is supporting the view of the Premchand Garg, supporting the view of Antule. The only issue is Delhi Judicial Service. That judgment has held that no central act or state act can limit or control the power of the Article 142 because it is a constitutional power. That judgment also held that the statutory provision has to be taken into consideration but cannot limit it. That is the SCBA case. So next come to Alawat case. In Alawat case, also same. In this case, what happened? One person has been convicted under 193 IPC. What does that mean? Giving false evidence. So when the Supreme Court found that one person has given false evidence before the court, by ignoring the statutory procedure, CRPC 340, some procedure is there. When a person committed any offense like fabrication of document or giving false evidence, 340 procedure has to be carried out. That means superintendent has to court staff has to give complaint. Court has to give complaint. But without those things, directly Supreme Court has given conviction. So Supreme Court held that court cannot altogether ignore the substantive provisions of a statute and pass orders concerning an issue which can be settled only through a mechanism prescribed in another statute. So, one statute prescribed a mechanism, but ignored 142 under 140. So, it is wrong. This is the Allahabad judgment. Next, come to latest judgments of Shilpa Shailesh. So, in Shilpa Shailesh, Supreme Court has taken a different view. Altogether, different view means added one preposition, one component, added one component. What is that component? It is a plenary power, of course, we know that. Conscientious power. So that means with due care, we have to use this power. It is unhindered. So we know that it has no limits. The power under Article 142 has no limit. But it must be, it must be exercised based on fundamental consideration of general and specific public policy. This is the new concept. So, the power under Article 142 has to be exercised based on fundamental consideration of general public policy and specific public policy. So, what is the meaning of fundamental consideration of general public policy? Here, fundamental general conditions of public policy refer to fundamental rights, secularism, federalism, and other basic features of the Constitution of India. So, if the matter or cause pending before it is related to these fundamental general public policy, then it can exercise. That is the concept. Then what is specific public policy? Specific public policy should be understood as some express preeminent prohibition in any substantive law. So, if any law prohibits something, 142 cannot come into picture and do the same, which cannot be directed by the statute. You cannot done it indirectly by the Article 142. So, express preeminent prohibition in any substantive law and not stipulations and requirements, a particular. It should not contravene a fundamental non-derogable principle at the core of the statute. So, complete the government or legislature made a certain act for the core purpose, but for defeating that purpose, if Article 142 has been used, that is wrong. That is the principle laid down in this Shilpa Shailesh case. You know that what is the Shilpa Shailesh case? It is the Hindu Marriage Act. What is the core issue? Whether by exercising Article 142, the Supreme Court can grant divorce without second motion. in mutual consent matter, and the same way can pass decree of divorce on the ground of irretrievable breakdown of marriage. So 6 months period, cool off period can be waived. That is the ultimate issue is that. So Hindu Marriage Act certain procedure is there. 6 months cooling period. That can be ignored under Article 142. That is the final. But the ratio regarding the statutory provisions is the important. So even in the strictest sense, it was never doubted or debated. And that means what? 142 has ample power to do complete justice. There is no doubt at all. But if there is any express prohibition in the statute, it has to be taken into consideration. Okay, come to without being bound by relevant provisions of procedure, if it is satisfied that the departure from the said procedure is necessary to do complete justice between the parties. So relevant statute has made a particular procedure. Supreme Court, by exercising Article 142, can departure from that said procedure when, if it is necessary to do complete justice between the parties. That too on the above condition. What is that condition? Fundamental, general, public policy. Like that. Then what is the difference between procedural and substantive law? Is contentious, but not necessary. Albeit means but are conjunctive, to be examined in depth. So that is. So what is the ultimate thing in Shilpa Shailesh case is that we can pass directions under Article 142 by departing from the procedural or substantive law, but subject to the above conditions. The next question is, this court can depart from the procedure as well as the substantive law as long as the decisions is exercised based on consideration of fundamental and specific public policy. While deciding whether to exercise discretion, this court must consider the substantive provisions as enacted and not ignore the same. But this court acts as a problem solver by balancing out equities between the conflicting claims. This power is to be exercised in a cause or matter. So this is the final. Can depart from procedure as well as substantive laws, but on consideration of fundamental, general, and specific public policy. Even then also, this must consider the substantive provisions as enacted, not completely ignore. So as a problem solver, this court, by balancing out equities between the conflicting claims, this power has to be exercised. That too in a cause or matter pending before it. This is in Shilpa Shailesh case. Okay, come to other judgment. That is High Court Bar Association. High Court Bar Association of Allahabad, 2024 judgment. Shilpa Shailesh is 2023 judgment. This is, you know that earlier Supreme Court in Asia resurfacing infrastructure judgment has passed one direction. What is that direction? The three judgment of Supreme Court various in ASEAN resurfacing judgment. The net effect of the direction issued para 37 is that in the petition in which the High Court has granted a stay of the proceedings of the trial must be decided within a maximum period of 6 months. If it is not decided within 6 months, the interim stay will be vacated automatically. So, virtually making the pending case infructuous. This is the direction in the ASEAN resurfacing judgment. This direction has been issued by exercising power under Article 142. So, once stay of the trial is granted, the case should be decided within 6 months. Otherwise, automatically the stay would be vacated. So, what is this effect? We know that the lot of troubles have come because of that direction. Then the Supreme Court in this High Court Bar Association Allahabad overruled that judgment by saying that it is a wrong direction. Now, in this judgment, Supreme Court has laid down 4 parameters for exercising the power of Supreme Court under Article 142. What is that? The jurisdiction can be exercised to do complete justice. It cannot be exercised to nullify the benefits delivered by a large number of litigants based on judicial orders validly passed in their favor who are not parties to the proceedings before this court. So this cannot be done. Article 142 does not empower this court to ignore the substantive rights of the litigants. So, substantive rights of the litigants cannot be ignored while exercising Article 142. While exercising the jurisdiction under 142, can always issue procedural directions to the courts for streamlining procedural aspects and ironing out the creases in the procedural laws to ensure expeditious and timely disposal of cases. However, while doing so, this court cannot affect the substantive rights of those litigants who are not parties to the case before it. The rights to be heard before an adverse order is passed is not matter of procedure, but a substantive right. So the power of this court under Article 142 cannot be exercised to defeat the principles of natural justice, which are an integral part of our jurisdictions. So all these 4 parameters are important for the exercise of the jurisdiction under this article, which are relevant for deciding the reference are as follows. A reference case. So, for that case, these 4 parameters are important. But here, there is no discussion regarding substantive provisions of statutory, but only litigants' rights, substantive rights of litigants, and Article 142 has been discussed. But one important principle has been discussed, that is regarding principles of natural justice. While passing orders under 142, these principles of natural justice cannot be ignored, cannot be defeated. So ultimately, the issue is that Article 142 and statutory provisions. Gradually, even in Shilpa Shaile's case and other judgments also, the ratio held in Premchand Garg case has been upheld. That normally it is a rare exercising of the jurisdiction, 142. It is a discretionary power. We know that it is a discretionary wide power. So while exercising this discretionary wide plenary unhindered power, we should not ignore. At the same time, these statutory stipulations, provisions cannot limit, cannot control the power of the Supreme Court under Article 142. So this is the final conclusion.